Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. We're continuing on with the quick-hitting contracts basics. Okay, so again, we're going kind of high level, talking about real basics to contracts and how they work. So we talked about the four corners of the contract, how really it should be limited to what the deal is in the contract itself. So what if there's something missing? What if there's missing information? Well, this is a little more complicated because you can have two kinds of missing information. If it's information that's essential to the formation of a deal, so I don't know, maybe a description of the property, any sort of information about what property is trying to be conveyed. Well, and then there's a disagreement about which property someone's buying. Well, that's pretty essential to the deal. So that might be deemed so impactful that information is missing that there is no contract. But anything else that's not deemed essential but still is going to be important. I mean, a lot of that information. So say a settlement deadline. I don't know if a settlement deadline, if a court would say that's so essential that the contract fails without it. And then the parties can't agree. Well, again, pretty far-fetched you'd ever have a court deciding that, because a contract for a real estate contract is probably not going to go that far to go into court to have a date filled in. But how contract law works is if you have missing information like that and parties can't agree, then the court can fill in what is reasonable. And so the court may decide what date would be reasonable or what information would be reasonable in those circumstances. And so, yeah, again, pretty far-fetched to get to that point that a court's filling in that information. But best practice is get it right the first time, right? Make sure you look through that, you see all essential information, and you include it. And then if something is missing, bring it to the attention of all the parties and have an addendum that fixes it and have all the parties sign it, and then you are good to go. What will be a little more difficult is if it's not like a part of the framework of the contract, so maybe it's an included item that the parties discussed. Maybe one party or both even believed it should be in there and it didn't make it in there. Well, that's not going to be easy to see for a third party on the outside. Oh, that was meant to be in there and now it's missing. Again, the four corners of the contract. This is the deal we're dealing with. It's not a blank that was meant to be filled in. This was additional information. So, again, you'd need to get with the other side and sign an addendum to add it in there. And if they don't want to add it in at this point, then you might be in trouble. You need to try to get it in there in the first place, because those are a lot harder to prove that it was meant to be in there when it's not in the signed deal. So, again, do your best to get it all in there in the first place. If you're missing something and it's clearly missing, have an addendum signed to add it in. Hopefully that is clear. Remember, this is not legal advice. This is legal information only. If you need specific legal advice, please contact your attorney. Thanks for tuning in.